Good evening. I'm attorney Lawrence Berliner. I'm an attorney in the field of special education law, and I'm with our co-host, Jane Faherty, who is an advocate and director of the JumpStart program. That's part of the Stamford JCC. It's hard for me to believe that we are now starting our 6th year of doing these webinars. But we are, and we appreciate everybody that has participated tonight and over the years. Before we begin, I have a quick disclaimer. We have many questions that we'll try to get to. If you have questions during the webinar, we ask that you put the questions in the Q&A feature at the bottom of your computer screen rather than in the chat. One reason is the chat is recorded as the rest of the webinar is. And we would prefer to maintain privacy. The Q&A questions are not recorded. We have put our contact information in the chat section. There'll be other resources there, such as the Back to School Guide, State, Federal Department of Education contact information. And so, as I mentioned a moment ago, the webinar is being recorded. The information in this webinar does not constitute specific legal or professional advice regarding you or your child's circumstances and should not be relied upon as such. The webinar does not establish a professional relationship with Jane Faherty, the Stamford JCC, Allie Grafman, or an attorney-client relationship with attorney Lawrence Berliner. Information provided during this webinar is based upon Connecticut state law and policies and federal or United States law. If you're watching this webinar from another state or another country, you should consult your local laws and policies that are in effect in your state. Zoom is a third-party provider and is not part of the law office of Lawrence Berliner, the Stamford JCC, Allie Grafman, or Jane Faherty. So without further ado, let's get started. Jane, I hope you had a good summer. This is our first webinar of the 25-26 school year. Anything new?
Hi, Lawrence. It's lovely to be back. I cannot believe that we're back to the 25-26 school year. No, just it's been a busy season so far, and we're only a couple of weeks into the school year. So I'm very happy to be here again with Allie and yourself tonight to answer the questions that we've had in before this evening's recording, and obviously to pivot and respond to the ones that we get through the evening. So lots to talk about, lots of different topics to explore, but it's lovely to see you again and to start our 6th year sharing these conversations. So Allie, it's great to see you again.
Same here, Jane. Nice to be with everybody, and welcome to our audience. It's always a pleasure to be involved with the webinar, especially in the fall when we have the entire school year to look forward to. And that's really our goal, that we look forward and we work together collaboratively so it will be successful. We don't want any family or any professional to dread the year. We want to make it as positive as possible. So we'll get to hopefully many of the questions tonight, and we'll leave you with food for thought, hopefully. And again, welcome everybody. Thank you.
Yes, thank you. We have many questions. We'll do our best to get to all of them, but unfortunately, we do have time constraints, and I don't know if we'll get to everybody, so we do apologize in advance if we don't get to your question. So I thought it might be helpful if we started with some changes that are in effect. The governor signed a law here in Connecticut called Public Act 25-67, which went into effect on July 1st. A lot of people are not aware of the changes, but there were many. This is available on the Connecticut General Assembly website, Public Act 25-67. It's over 40 pages. I am not going to go over 40 pages of this legislation, but I do want to just point out a few highlights. The definition of developmental delay, one of the eligibility criteria has been expanded from age 5 to age 8. I might add that when I was working for the Protection and Advocacy Office many, many years ago, that's exactly what I had advocated for when I was part of a task force in the late 1980s or 1990s, but the committee voted age 5. So I'm glad my comments were realized about 30 years after the fact. Another requires functional behavioral assessments. Under federal law, it was unclear what a functional behavioral assessment is. We have a Connecticut definition. We have a requirement that before there are out-of-district placements for therapeutic reasons, that we have an FBA, a functional behavioral assessment, and a behavioral intervention plan in place. Another change was revisions to the due process hearing procedures, where hearing officers can limit the number of days to 4, changes part of the parent's burden of proof for out-of-district placements. Another change, which I'm very concerned with, it allows the Department of Education after January 1st to remove the service implementers from the IEP. Right now, when you have a service, you're supposed to know who's providing the service: a special ed teacher, speech and language pathologist, paraprofessional, others. That section will be gone after January 1st, 2026 in the new IEPs. Lastly, there are others, but lastly, the Department of Education has an Office of Dyslexia and Reading. And there's been a lot of controversy over the office, so much so that one of the directors basically resigned because she was not allowed to do what she thought she should do. So there will be a report, probably some public hearings by the Department of Education, because a report has to be provided to the General Assembly prior to February 1st on evidence-based practices regarding dyslexia, intervention, student outcomes. And those were part of the state Department of Education, the state legislation, some of the affecting the State Department of Education. So where would you like to start, Allie, Jane?
Well, I think that's a great state update. And just to piggyback on what something Allie briefly touched upon, the wonderful thing about our conversations that we have, Lawrence, with our guests that come on, a variety of different topics that we cover and explore together. We also actually have some educators that join in these webinars and enjoy learning something from our conversations. And one of our questions tonight came in from an educator who was just wondering on how the dismantling of the Department of Education might be impacting the IDEA, if at all it is being impacted. So I know that we're just talking broad brush strokes here, but in addition to these state changes, are there any other things that parents and educators or those in the field should be maybe aware of or paying attention to?
Unfortunately, the answer is fortunately, the answer is yes. Unfortunately, there's not a lot of solid information out there for parents or educators or both. We have executive orders being issued. We have policy pronouncements being issued by the Department of Education, the United States Department of Education. We have litigation over these executive orders and policy pronouncements. We have the Congress failing to enact a budget, which goes into the federal fiscal year is October 1st. We don't have a budget, so we don't know how much money will be appropriated for the upcoming federal fiscal year, which starts on July 1st. We have Department of Education employees being fired, rehired. The civil rights enforcement activities of that agency are in effect, not in effect, or substantially curtailed. We have functions of the Department of Education that may or may not be relegated to the Department of Health and Human Services, the Department of Labor, and the Small Business Administration. So we have a lot of funding, discretionary funding for teacher training grants, for example, that have been rescinded. There's a lot, unfortunately, there's a lot in flux right now today, and we have the school year already starting late August. We're halfway through September, as Jane pointed out. And on the federal side, we don't have a plan that's in effect financially for the federal fiscal year. And we have all these policy pronouncements. One of my colleagues who works for the State Department of Education told me early in the summer, I don't know what to advise my client, the state agency, because we have these changes that are sometimes happening by the day and several times during the day. And that, unfortunately, is where we are right now. So the one thing I can say is if you are very concerned, as all three of us are, make sure your elected officials, your United States representative, your United States senator, hear your voice. And for example, Senator Chris Murphy from Connecticut is on the Senate HELP Committee, which stands for Health, Education, Labor, and Pension. That's a committee of cognizance, which means he has jurisdiction over educational issues. Let his office know your concerns. Representative Rosa DeLauro, who covers the 3rd District, which is Greater New Haven, is on the Appropriations Committee. Let her know that the funding should be there and whatever else you have concerns. And unfortunately, it's an excellent question. Unfortunately, it's an excellent question. We just don't have, or at least I don't have all the answers because there's so many things in flux. Pending legislation, pending litigation, a Congress that needs to legislate and appropriate funds. But one last thing, there's a move afoot to block grant the federal funding, which means the states will have a lot of discretion on how, with little accountability to the federal government. None of that is in place right now today, but those are things that are potentially on the horizon.
So to summarize, I think that we all feel in this field of education, educators, parents, and those in related service provider fields, that there is a loss of oversight, and there's probably going to be changes in funding and compliance. So what we can do is, if you are parent and you're concerned, you can reach out to advocates such as myself or Allie. And if you feel that you need something a bit more of substance, you can contact attorneys such as Lawrence as well to help guide you through these unprecedented times once more. So in terms of getting back to some other questions that we've been asked tonight, obviously, the summer is a time that people might move, relocate. And we had a question from somebody that said, what do you do if the school says that the IEP from the other state or the other district needs to be changed? Allie, do you have any thoughts on how to handle those situations?
Well, it's definitely incumbent upon the receiving district to have a PPT. Out of state calls them IEP meetings. Connecticut calls them pupil planning placement team meetings. So a PPT needs to be called, and because it is a different state, you would have a Connecticut IEP. So usually it's not it's not definite as far as time, but the typical time duration is about a 30-day transition period. So when a student moves, give or take 30 days, the receiving school will have a PPT. Many times it's sooner, but it can be up to 30 days. And that is called a transition PPT from one state to another, and you develop a new IEP. It doesn't mean that the receiving district, Connecticut, won't accept most or many of the instructional methodologies, as well as the goals and objectives. Very often they do accept them, but certainly the school district also has the obligation of introducing their own. So yes, you do need a Connecticut IEP when you move from one state to another.
And then this is a follow-up question again that we received before this evening's recording. How do you make sure that adaptations and modifications itemized on an IEP are actually implemented and followed up, whether it's for elements to happen during the school day, or and then how to maybe use some of those tactics to help your child do homework after the fact as well?
So I get this question asked a lot by my clients because many IEPs are very rich in accommodations and modifications. You could have pages full of them. And who knows if they are being followed up. It's easier to, I guess, create accountability at the elementary level because there's only, a few teachers involved. But as you get up to middle and certainly in high school, you've got a team of teachers. So what I often suggest to my clients is to schedule what I call team meetings. And the team meetings are not PPTs, they're informal meetings. They can be remote, they can be in person. They're usually shorter than PPTs, but you can invite the teachers that you'd like to have, or all of the teachers that are seeing the student. And you can also set an agenda prior to those team meetings so you know what you want to talk about, and then question the teachers about those accommodations. Also, if your child should have a case manager, if he or she has an IEP, and that case manager is also responsible for connecting with all the teachers to ensure that the accommodations and modifications are being implemented. So your basic or your first contact would be the case manager and question and ask for data to evidence the fact that those accommodations are being followed.
So the worst case scenario, Lawrence, we had a question here. If a parent got so perturbed and frustrated that they wanted to consider doing a class action lawsuit in a school district, is that possible? And what success typically do they have with taking those steps? And could you also define and let people understand what a class action lawsuit is too, please?
Certainly. Class action lawsuits, most litigation involves individuals. Class action lawsuits, generally speaking, involve a group of individuals. In the context, but one of the things the courts look at are the group of people who are representative of a class. Do they have a lot of things in common? So if we're dealing with children with disabilities, some may have autism, some may have intellectual disabilities, some may have orthopedic impairments, some may have specific learning disabilities, on and on. What do they have in common? And often the courts say there's not enough in common because children are unique. Their IEPs, letter I is individual, that's unique. And the courts generally will not allow a class action lawsuit against a local or state board of education. There are some very limited exceptions where if there are systemic violations. One case that I remember was against the New York State Department of Education, where the federal law requires due process hearing officers not to be employees of the Department of Education. They have to be independent or independent contractors. And New York was sued in a class action lawsuit because everybody who was part of the class would be affected by the fact that the state Department of Education in New York was using state employees as hearing officers. So that was one of the rare cases that I'm aware of where a class action lawsuit was allowed to proceed by the courts, because you have to show commonality, a whole bunch of other things. So what I have found over the years that sometimes when you file a lawsuit involving a single individual, if you prevail in that lawsuit, it has a spillover effect. So like a ripple effect, you throw a stone in a pond, it's that ripple effect. So sometimes if you win on a single individual wins or prevails, that's going to have a carryover effect. So rather than arguing numerosity, arguing commonality, all other parts of the federal rules of civil procedure, I generally point out it's not advisable to file a class action lawsuit when I'm contacted. If there's a lawsuit to be had, there are what are called mandatory exhaustion of administrative remedies that have to be pursued, called the due process hearing. There are exceptions to that, but generally, if a parent has to file a request for a due process hearing and before going into state or federal court. So that's sort of a thumbnail sketch of the federal rules of civil procedures and why most class action lawsuits against school districts fail.
And just for those of you not in this, or those in the Connecticut, just to understand that if you are pursuing a due process or attending a due process hearing, advocates such as myself and Allie would not be able to represent you. That is where you would need to reach out to an attorney such as Lawrence to help you navigate that due process system and the procedures. So this is a question that sadly often comes up at the beginning of the school year, but I know that some students might already be struggling with school refusal. So Allie and or Lawrence, what would you do in the event that you have an IEP as a parent, you are concerned maybe it's not being followed to the letter, and as a consequence, you're seeing that your child is already beginning to refuse to attend school on a regular basis? What advice do you have for those parents at this point, early in the year, to try and nip it in the bud?
Well, we have a mandatory school attendance law that I forget the exact number. I think if you exceed 10 or 14 unexcused absences, that could result in claims of truancy. So you're adding a problem to problem. If the child is not going to school, in Connecticut, we do have a homebound tutoring option, which is a temporary expediency. If there's a verified medical reason, that's what it's called in the regulations, where a physician fills out a form, states the reason the student should be on homebound instruction. Often it's 5-10 hours a week, mutually agreed upon time, date, and location. But the more fundamental question is, why isn't the student going to school? And that may require evaluations and maybe other sources of information. Is there bullying going on? Or sometimes there are problems outside of school. Sometimes, there are self-esteem issues. It's trying to get to the bottom of why the student doesn't want to go to school is important. Parents sometimes are the best source of information, and sometimes school districts, sometimes outside professionals to get to the bottom of it. There's no one size fits all approach. But what I advise my clients is to don't wait, don't avoid, but try to do something be proactive. Informal meetings, PPT meetings, which are the formal meetings, CSE meetings in New York. These are the IEP meetings. So your concerns are documented. If homebound as a temporary expediency is an option, let's explore that. If we have to revise the IEP, we have to look at where, when, and how the wheels went off the rails. Let's do that. Sometimes we need a functional behavioral assessment, psychological assessment. Sometimes it's sensory issues, an occupational therapy. Often there is a root cause, but finding that root cause is sort of like you're a detective in a mystery novel.
So Allie, if you do have concerns and you think that certain evaluations you'd like the school district and the school team to explore for your child, what steps would you take as a parent in order to get those evaluations agreed upon and implemented?
Well, if your student is not in special education at this point and there are school refusal issues, then you definitely request a PPT. It is a considered an initial PPT or a referral PPT. And at that first PPT, that referral PPT, that's when you request an evaluation. The school will help you design what evaluation tools or procedures need to be implemented. Of course, if you had an advocate or an attorney, they can certainly advise as well. But there are different types of tools that can be used to be able to determine what your child's needs are. After that evaluation, then you come back to a PPT. The school does have 45 school days to carry out that evaluation. So you're talking about a good interim of time, and I'll come back to that in a moment. But after those 45 school days, then you come back and you see if your child is eligible for special education services. If so, then you develop an IEP. Within that IEP, there needs to be a plan of re-entry or some type of plan to help the student, whether it is homebound services, whether for temporarily, not long-term, temporarily, or re-entry with many, many supports and significant supports within the school. Whatever that plan is, that's what the team develops and helps you as a parent or as a family to come together to develop that plan. Now, going back to that 45 days interim, that's a long time for any kid to be out of school, just refusing. And I've had clients that have spent that much time and are saying, oh my gosh, that's horrific. So during that time, you need to work with the resources within the school. And those people would be most likely the social worker, the school psychologist, or in the upper grades, their school guidance counselors. Any one of them or all of them really need to come together and get to work together collaboratively to understand what the nature of the problem is. There are many strategies that can be implemented for your child during this 45 days. It's a unique situation, so I'm not going to go over every strategy, but you do have resources within the school to support this before you come back to a PPT and develop an IEP if your child is eligible.
The other thing too that Lawrence and I have been talking about a tremendous amount of the last 6 years is data collection. If you as the parent are really concerned about some elements where your child might not be meeting their full potential, whether it's academically, socially, emotionally, physically, within the realm of OT or their behavior, keep anecdotal data, videos, examples of work that they've produced when at home, or pay attention to how long it is taking them to complete their homework independently. And the word is independently. What supports have you had to provide them in order for their homework to be completed? The devil is in the detail, and don't be afraid to collect data and information. And also, if you are using outside private practitioners and supports for your child, bring those individuals into the conversation as well. They can attend the PPT. You are allowed and eligible to invite people to attend, to share insight as to who your child is and how they connect and engage with different material or individuals, or certain supports that they respond more to than others. So bring information to a PPT. Do not be afraid to share. And even if you think it's not relevant, it might be relevant to somebody sat around the table. There's no harm in oversharing information at these times. So gather the data. If you've noticed things over the summer, even though it might feel like it was a long time ago, it's still relevant, pertinent information. And you can look for trends in your child's behavior too, and together collaborate with the team on that information. And don't be afraid to bring other people and supports to that meeting to help you communicate and share that data along the way as well.
Jane, I just want to piggyback on that for a moment. What I'd like to ask the team is, before you come back to a PPT, ask the team to give you that data prior to your PPT meeting, because it's overwhelming to try to really understand everything at a formal PPT. So if you have it before, all of the data, and you have to use the data that is being provided by the district, but if it is not sufficient data, you are entitled to ask for specific data, whether it's in graph form or whatever, logging that they use. Data does support that instruction, and you are entitled to see that data before the PPT. So that is something that you want to keep in mind.
Yeah, otherwise, just to add on that, if you're being provided with a ream of documents for the first time that you haven't seen before, what I do is just, when I'm at the meetings, I just say, we don't have time to process this. We're going to have to adjourn and reschedule a meeting. So we're wasting time, energy, and money. So the best thing to do is, Allie point, get this information ahead of time. And that way we can have a chance to review the documents, if necessary, speak to the teachers or the other school staff, and have a productive meeting. And just to add to Jane's comment, parents are a very important source of information. You see your child in multiple settings. The school staff typically sees them in one setting called school. And so what I'm looking at, if the school is saying that the child has learned a skill at school, the child should be able to generalize that skill outside of school. And that's where the parents are very important. Can the child do a consumer transaction, for example? Can they read a menu in a restaurant? Can they do the homework independently at home? All of these are very important pieces of data that parents can collect, and it's relevant to showing whether the child is learning skills in school, making meaningful progress, and, as I mentioned a moment ago, being able to generalize those skills to other settings. And I just want the person that's asked about notice of PPT meetings, quick question. The answer is, in Connecticut, school districts are supposed to give you 5 school days advance notice of a PPT meeting, who's going to attend, the purpose of the meeting. You can waive that, but in Connecticut, the schools are supposed to give you at least 5 school days notice.
I think for me too, once you have an IEP and you've agreed upon the goals and the goals and objectives that your child is going to work upon, the devil is then in the detail. I was working with a student who had 4 letters in their name, and one of the goals was that the student would successfully be able to write their own name independently. But it was deemed to be mastery if they did it 50% of the time. So that's like a coin toss to me. And when you only have 4 letters in a child's name, that really is a low expectation, I believe, for that student to gain success and mastery. So pay attention to the devil in the detail. And that means when it says what percentage of that, once that goal is mastered, is considered mastery, challenge them. 50%, 70%, I don't think is sufficient to say that that is mastered. If you think about that in context of a name, is it okay that 50% of the time you spell your name correctly? There could be a big difference between names if you put in 2 letters that are incorrect, could mean completely different things. So pay attention to what is considered to be mastery. And also pay attention to when the school says, when you get the progress report later in the school year, and the school claims that a child has mastered it, to what extent have they mastered it independently? And are they able to generalize that skill across different settings, different adults, different domains, and within different distracting environments? Because if they can't, then maybe they haven't actually mastered that particular goal or objective. Any suggestions on that, Allie or Lawrence?
Well, I can go on and on about the IEP because there's so many details, but you hit on an important component there, Jane, about looking at the details on the objectives and what mastery really means. It is not totally user-friendly for somebody that is not in education. When you read the criteria, something like John Doe will master 4 out of 5 times writing his 4-letter name. Okay. What is 4 out of 5 times? Does that mean after 4 times, that whole IEP year, he writes his name, the 4 letters, he's check off, he's mastered. No, that doesn't sit well with me. It shouldn't be 4 out of 5 times anyway, that's minimal, but let's just say it is. It needs to be consecutive. I always insert that word consecutive in the objectives, because 4 out of 5 times or 8 out of 10 times, whatever it is, out of the whole year, is certainly so low in rigor. You want to make sure, as Jane said, that it is generalized. So when your student does it consecutively X amount of times, you can pretty well say, okay, he's got it. But that word consecutive is, to me, is paramount. And many of you wouldn't know that because it takes a lot of experience reading these IEPs to look at those objectives in detail. So that's just a hint that I have.
The other thing that I think is interesting sometimes is when you're at a PPT and they are telling the parents and myself that the student is an absolutely incredible reader. They are just wonderful at reading. So, for example, if you're with a 3rd grade student, you say, that's great. Are they reading at a 3rd grade level? Oh, no. They're reading at a pre-K level, or they're reading at kindergarten level, but they're wonderful readers. So also pay attention to, and this is the good time of year to do it, collect that baseline data. Where is your child performing compared to the neurotypical grade peers and the expectation for that school grade? Because what you want to identify at this time of the year is the baseline data from which you can then track and monitor, hopefully, meaningful progress throughout the school year. If you don't collect that data at this point, it's more difficult then to determine, has a child made progress? Have they plateaued? Have they regressed? So you really want to establish that baseline data at this stage from which to build upon. You then want to make sure that there's certain touch points throughout the year where those evaluations are repeated to really monitor and track your child's progress. At a bare minimum, you want it probably 3 times a year. You'd want it now, you want it at the mid-year and at the end of the year to really track progress that's being made. But also pay attention to what they are using to track that data. For example, I had a student that is very adverse to iReady programs, and being anywhere near an iReady program triggered anxiety. Therefore, that student, they weren't able to collect meaningful data. So if you know, for example, that the child is going to respond adversely to a particular methodology, there's a plethora of different tools that can be used. So don't be afraid to ask the district to explore different tools and different means of data collection to establish that baseline data at this point in the school year. I think that is so important. We don't want to wait until April to determine where your child is compared to their grade level peers. Any other feedback on that, Lawrence or Allie?
Just
No, that's
to
very,
reiterate, go ahead, Larry. Go ahead.
I was just saying that's very important because the example I used was several years ago. I had a middle school student. It was either Ames Web or Dibbles, which is a curriculum-based assessment that's used beginning, middle, and end of year. Long story short, we had these absolutely beautiful colored graphs and showing that the student was reading at the top of the page, 100%. And this was just shared to us during the PPT meeting for the very first time. I look at the very bottom of the page. The norm, this is the middle school student, the norms were set for 1st, 2nd, and 3rd grade. So this student was reading 100% at 1st, 2nd, 3rd grade level in middle school. So it's important to, in effect, read the fine print. I can't, that's why, as Allie pointed out, get the data ahead of time. Fortunately, I was able to multitask and read, listen, and write, but my clients often don't operate the way I do. So it's very important to get that data, make sure it makes sense. The other thing I just wanted to add was the goals and objectives. Use plain vanilla common sense, rather than trying to understand the language of the IEP. What are they trying to get at? Are we trying to close the gaps with reading, math, social skills, whatever's in the IEP? I had a case many years ago for a visually impaired student. This is a true story. I'm not being facetious. The goal for crossing a crosswalk was at 80%. Well, what was supposed to happen with the other 20%? 80% of the time for that goal was not appropriate. It should be 100%. And that's why we don't generalize 50%, 80%, 70%. It should be meaningful. It should be measurable. And ultimately, we're trying to close the gap and get the student from point A to point B. That's what the meaningful educational progress is.
Absolutely, Lawrence. And it's interesting. That's a great example. I had a similar one with a play frame structure to keep the child safe. It was considered mastery if they, didn't accidentally fall off the play structure X percentage of the time, the same concept. And I also think it's really important for everybody to understand that just because you have an IEP and you might need more support and services doesn't mean you're not still striving to be a student that reaches their full potential. And so we don't accept mediocrity from the teachers just going through the motions. We want them to put the same effort into our students as they would do other students in the programming too. It should be an even playing field from that perspective. Obviously, lots of students have transitioned into new school environments, whether it's elementary, middle, or high school. Any suggestions if a child is still struggling with those transitions in their new school environment? Any ideas or suggestions on what conversations their parents could be having with the district, or any strategies that they could potentially be sharing with the PPT team or during team meetings? Allie, have you got any ideas on that one?
Well, if your child is struggling in a new environment, I think it's important to work together to identify what the feeling of insecurity is. It's always good to pair professionals. In other words, if your child is in a middle school and had maybe a case manager last year that he or she felt very safe with, it would be nice to pair that case manager, not all the time, but a couple of sessions, so that your child sees somebody new with somebody that he or she felt safe with. So use the resources within the school, I believe, to really underline that feeling of security and confidence. Positive behavior reinforcement, and make sure, ensure that all teachers are using, and it's easy for a teacher to say, oh yeah, I reinforce positively, but what are those procedures? Some students don't like to be called out amongst, in the classroom, don't like to be called out and be isolated as far as, oh, Johnny, you did a great job. That could be very embarrassing to that student. So how does your student or your child respond to positive reinforcement? Is there need to have that type of reinforcement much more, done in privately, or is it better for him or her to have that reinforcement amongst the peers, whatever that is? But positive reinforcement, making sure that the resources are there to support your child, are really important ways to secure safety.
I think it's also, this is a good time of year that if your child has been in any private therapeutic services during the summertime, whether it's ABA, speech or OT, it's also important to remember to allow the conversation to take place between your private practitioner and the expert within the school district, and sign those releases of information so they can share strategies, so that in some instances the new school team isn't coming into this situation cold, and they have a little bit of background knowledge as to some strategies that might have been successful for that child's transition to be smoother into the school year. And we had a question, can ABA therapists be allowed in schools? I have worked with teams and schools that have allowed private practitioners to go into that school space to support that child, and in some instances to help educate the team that are now assigned to that child, so that they can smoothly employ and utilize skills that have already been proven successful for that student. So depending upon the school's ability, it is possible, and it's often quite helpful for private practitioners to come in and demonstrate and maybe model how they've had success engaging with a student in their practice, so that the acclimation and transition into a new school environment can be a bit more seamless.
Yeah, just to add to that, on the observation piece, two things. Each school district has an observation policy. Typically, it's on the Board of Education portion of a school website. And our State Department of Education has a guidance that's on independent evaluations and in-school observations. The second part is in-school observation. And it's a very useful working document. It's available on the State Department of Education. ct.gov is the state website. And you want to be able to work in collaboration and setting up an observation, whether it's a parent observation, an ABA coming in, any other person. Often the schools resist that, but there are policy pronouncements that basically say if a school psychologist did an observation as part of an evaluation, a private psychologist should have the same opportunity to observe a child. Because, you know, on one hand, you want knowledge. On the other hand, you want to get the best information. And sometimes when there's a strange adult in the classroom, it disrupts the classroom. You know, who is that person? Are they watching me? So you want to be able to make sure you have the best opportunities when you have in-school observations. So look at your local district visitation observation policy. Look at the State Department of Education in-school observation guidance.
In the wonderful world of special education, we like acronyms. We use acronyms a lot. And one of the things that some parents get confused about, in addition to acronyms, is what is the difference between an IEP, an individual educational plan, and a 504 plan?
Wow. The problem is both laws cover students with disabilities, but they have different outcomes. A 504 plan is about accommodations, modifications in a school setting. So if you need extra time, alternate test setting, a pass to the school psychologist, or if you have a medical condition, you have a pass to the school nurse's office. If you're out for school because of a medical condition, the plan might also have how many days do you have to make up missing schoolwork. An IEP is a much different document, even though it's covering a child with a disability. We have 14 categories of eligibility. 504, it's almost an infinite number of disabilities that establish eligibility. An IEP has goals and objectives. A 504 plan does not. You have services like counseling, occupational therapy, speech and language in the IEP. Generally speaking, the 504 plan does not. One of the things we talked about earlier was accountability. Data has to be collected for the IEP to show progress, meaningful progress on a goal, whereas a 504 plan does not. The enforceability of 504 has procedural safeguards, but those are different than the IDEA procedural safeguards. So sometimes you have a student with a disability that needs direct instruction, goals and objectives, and accommodations, and that could be in an IEP. And sometimes you have a student with a disability that only needs accommodations and no direct instruction, and that would go into a 504 plan.
So Allie, I know that both you and I were talking before the webinar that we've both encountered some really sad situations where sometimes a school has requested that a parent pick a child up early, and that ends up being the consistent routine that the child then isn't fulfilling the full IEP educational hours, that they are missing many of the school days and hours because the parent's been asked to pick the child up early. Can a school force a child to have a shortened day? And what would the steps that a parent should take in order for either for this to happen if they think it would be beneficial, or to prevent it from happening?
Well, I think in the case that you just cited, the parent is asked to pick up the child, Jane, is that what you're saying?
Correct.
Yeah,
Yes.
okay. Not volunteering, but asked to pick up the child
Correct.
because the school can't manage the child, or the child is
Yes.
requesting to go home. Okay. So technically speaking and legally speaking, and Larry, you can vouch for this, the school cannot shorten the days without parental consent. Okay, that is not permitted, unless it is through either the PPT process or the 504 process that the family and the school mutually agree to that for the benefit of the child. It is when that happens, it's usually not a long-term situation. It is usually an interim plan that is developed, and with time, the child gradually gains back days and hours, and then ultimately, goes through his or her full day. But the school cannot, under any circumstance, dictate to the parent that we're reducing the hours. If that happens, then you need to really go back to a PPT and probably request either an alternate out-of-district placement if you feel that this particular placement is not accommodating your child's needs, or ask for whatever resources the child needs in order for the child to remain in school for those many hours of the day, for a total school day.
And to add upon that, there is a page in the IEP towards the end that specifies the school day, 6.5 hours, 6.75, whatever the school day is, 5 days per week, 182 days a year is often listed. And that means the child should be in school full time, 5 days a week, 182 or so days per year. When that's not happening, as Allie pointed out, go back to a PPT meeting. Now, this isn't the problem. The capital P problem is sometimes when parents say, look, I'm at work, the problems are at school, the solutions are at school, why don't you deal with it? And the schools will threaten to call 911, 211, Department of Children and Families. Now, sometimes, as they say, discretion is the better part of valor. So parents can be 100% right in saying my child's entitled to a full day, but the school might call DCF, they might call 911, they might call 211. So you have to be very judicious in understanding why they're calling you. If this is isolated versus a pattern in practice, that's one thing. Sometimes we have an emergency exigent situation at school, pick your child up. But if this is part of a pattern in practice, 3-4 days a week, pick up your child, there's something amiss with the IEP that's not allowing the child to derive benefit from a full day IEP. And as Allie pointed out, if by agreement we want to modify the school day, that's permissible, but it's done by agreement, not unilaterally by the school district.
I'm conscious that we're coming to the end of our time, but I have 2 questions here I'm going to roll into one. So if you have an IEP and you have a nonverbal child, how do you actually make sure and really know that your child is receiving the services that have been specified and agreed upon in the IEP document? What documentation can you request from the school district to make sure those services are being provided in accordance with the IEP? And secondly, if the services are being provided, what entitlements do the parents have to know who is actually implementing the related services, who is interacting and teaching your child throughout the day?
I get this question asked a lot, even when children are verbal, because often students don't have a really realistic handle on who's doing what and how much services they're entitled to and so forth. So One of the strategies that I like to implement is asking the service providers, that means special education teacher, OT, PT, speech and language, social worker, school psychologist, whoever's working with your child, to create a log. A log meaning when he or she sees your child and for how long, and you can even ask what, what goals or what was worked upon during that time. They're probably not going to be very receptive to it, but certainly it is within your rights as parents and guardians to ask for a log. If the child is missing sessions that are not due to his or her absences, it is incumbent upon that service provider to make up the time that is missed, regardless of their excuses, whether it's illness, or whether they're at another meeting, or whatever it is. If the child is in school and he's not being provided that services um, of what he's being IEP'd for, or what the IEP states, then the services need to be made up. So that's one strategy. Another strategy that I ask for is a weekly some type of communication between the service providers, the special ed teacher, and the family. What, daily, it can be daily depending upon the situation, but whatever is meaningful for you, whether it's daily or weekly, there should be some type of communication. And oftentimes I have the parent state, what information do you want that is meaningful and informative for you to be on this weekly communication? Because if you don't state that, then the teachers will make up their own form of communication, which may not be helpful at all. So I think that weekly or daily communication is really another very good strategy to utilize.
I think the devil is in the detail again too. Pay attention to on the IEP when you're looking at the number of minutes of service times that your child might be receiving one of the related services, OT, PT, speech. Pay attention to not only how many minutes, the frequency, who is going to be administering it. Is it an SLP, is it an SLPA, for example, but also what location is that service going to take place in? Is it an individual session? Is it a small group session? Is it going to be push in or pull out? All of those things might also make a difference for your child. And in addition to that, some of the goals might need to be in a small group with other students if you're working on, for example, linguistic pragmatic skills. Other things might actually need to be focused in a quiet one-on-one situation, maybe articulation and that motor planning needs to be conducted in a place where there's less distractions for that student to focus. So in addition to looking at the number of minutes, the frequency, who's going to be administering that related service, also look at the location it's going to take place in as well, and make sure that that is correctly itemized and noted too.
All excellent points, and that's where parents measure progress, the way parents measure progress. So if the child is receiving all of those services in school, but you're not seeing that generalized, why is that happening? Are they providing services on paper, but in reality, that's not happening? And there are multiple ways that parents can find out. One parent asked, can I observe my child? The answer is yes, but as I mentioned before, there are school observation policies on the local level. The state has a guidance, State Department of Education has a guidance on that as well. Sometimes parents get private evaluations as a way to validate whether or not the progress is there. Is it meaningful, not trivial? Is it measurable? These are all very important things because what we're trying to do for any child, let alone a child with an IEP, is getting them prepared for each next step in their lives, preschool to elementary school, elementary to middle school, high school, and preparing them for life after high school. In Connecticut, the age of eligibility is through the end of the school year when the student turns age 22. Some states it's 21. And it's important that you're part of the process. It shouldn't be an us versus them, but us, you know, a circle. We're in a circle, not on opposite sides of a conference table. And that's what Congress intended back in 1975 when they created the special ed law. And here we are many years later, we're still trying to figure out what a free, appropriate public education means. What is a least restrictive environment? What does that mean? And how do you measure progress? Is it meaningful, trivial? And these are all important concepts that parents need to be part of that conversation.
I think that a lot of the times too, when a family calls me, it's quite often at the point where communication has broken down between the parents and the district. And I think I don't see myself as being adversarial during PPT. I can be assertive if I need to be, but it's about building collaboration and effective, timely, efficient communication. So if you beginning of the school year, if you start to get that feeling or your intuition is telling you there's something not quite right, don't wait for that problem to be really present itself. Really start to address and have those conversations with the teaching staff that are working with your child. Ask for those team meetings if you don't feel comfortable initially asking for a PPT meeting. And remember, you don't need to just have a PPT annually. You can have more than one PPT a year. Even though the school districts often say it's your annual, it doesn't mean you just have to have one PPT meeting a year. And also remember that when you do have a PPT meeting, you are allowed to record those meetings. You need to let the school district know at the time, I'm going to be recording this conversation. You cannot do it secretly, and that is not allowed in the state of Connecticut. And the school district might say, no problem, we're also going to record the meeting too. So just don't be afraid to communicate. Don't be afraid to record that communication and then follow up after a PPT with written documentation, maybe bulleting what you agreed, where you disagreed, where you have agreed to take the next steps. Capture all of that. Don't depend upon the district to present that in the prior written notice either. You can have agency over this situation by not only having verbal communications with teachers that pick up drop-offs, but also then following through that communication with written form to document what it is that you've been discussing and sharing with the teacher, because that again can be used as meaningful data as the school year progresses. So when you get to January, for example, you say, you know, I've been concerned, we've been having these regular conversations. You're not just depending upon them saying, oh, I don't remember, I don't recall, I'm not sure I said it that way. If you would document these things as we go, it also helps you keep a track of progress and what you've agreed to together. And that collaboration to me is really a key word. And when you're in a PPT session, it's also a good opportunity to have cross-pollination of ideas and brainstorming amongst the professionals around that table. It's amazing how often they'll say, we talk all the time. They might do, but not necessarily in the detail that you require them to about your child. So encourage the speech pathologist to talk to the PT, the OT, the behavior therapist, because together they can also brainstorm on how to help your child connect and engage during one of their therapeutic sessions that they might be struggling with. You can also request that additional related service sessions, maybe for that collaborative experience between practitioners as well. So don't feel that you can't encourage communication, not just between yourself and the individuals, but between the team members as well.
Jane, I think you made an excellent point, and just to reinforce, I call them the 3 C's: collaboration, communication, and coordination. To begin the school year, all those 3 C's are so significant to be able to have effective relationships with all of your students' providers, the team, teachers, administration, and so forth. Don't wait until the middle of the year to start this process of collaboration and communication. In coordination, meaning that you want to have them understand that you're bringing everything together, all your energies, all your information, you're coordinating everything for the benefit of the child. So that's so important. And you have the whole year ahead of you to build on those relationships to ensure positive communication skills amongst all of you. And I think that's really what creates success for your child.
And no question is a silly question. If you don't know the answer, just ask. You might also, through asking a question to a team, there might be others around that table that also had the same question mark, but were too afraid or too intimidated to ask that question as well. So just ask whatever it is that you want the answers to. Don't feel that there's never anything you cannot ask. This is your child, and you should have privy to that information.
Just to add to that, as Jane pointed out, having a written record is very important. I believe my clients, when they have a telephone call or a meeting with the school administrator, but we can't prove that. But when you have an email, a note, a letter, summarizing what transpired during a conversation or a meeting, or sending an email requesting an evaluation or something along those lines in writing, there's a written record of that. And that's very, very important. At the beginning of the school year, I know we're a couple of weeks into the school year, many of my clients will send the teacher or the principal, especially if it's a new school, a note outlining what works for my child, likes, dislikes, because the teacher doesn't know your child as well as you do. And certainly they don't know the last year's, school or teacher. So if there's something that you want to bring to the table, let them know ahead of time. This is my child, this is what works, these are strategies. The other thing, we had many, many questions, and they had a common theme with the answer, at least my answer. You need to know your procedural safeguards. Those are your rights. Connecticut has, in addition to the procedural safeguards, a parent guide to special education, which some school districts provide to parents when they provide the procedural safeguards. And if it's not, it's on the state Department of Education website, ct.gov. It's important that parents know the rights. It's important that parents know how to enforce the rights. And on a day-to-day basis, parents are the best and the most effective advocate for their child. Allie, Jane, and I can get involved, but you're there as parents every single day. And it's, as Jane pointed out, it's a collaborative process. It's not an us versus them unless communications break down. You have rights to go to a due process hearing. You have rights to independent evaluations. You have rights to data. You have rights to file informal complaints, rights to PPT meetings. These are very important rights, and they only work when parents are acting upon those rights. And that way, small problems remain small, they remain few in number, and the child benefits from all of this. I see we're getting close to our appointed hour, as Jane pointed out a few minutes ago. So I want to thank Allie again, one of our returning champions, for spending some time with us this evening. Jane as well, sharing your insights. And all of you who are still with us, and there are quite a few, and we appreciate your attendance, your questions as well. Our next webinar is scheduled for October 22nd at 7 p.m. Our guest will be Dr. Terry DeLisa, who's a psychologist, and we'll be discussing a topic of supporting parents of children with special needs and navigating their child's journey through life. Dr. DeLisa is an experienced practitioner for students with autism, learning disabilities, dyslexia, and other conditions. If you found this evening's conversation informative, we welcome you to your continued participation at the next webinar. We have this for those that ask, this is recorded and will be available on YouTube from the Law Office of Lawrence Berliner, as previous webinars recordings are available. I want to thank Allie again and Jane for the collaborative efforts. I also want to thank my daughter, who's off camera to my immediate right, because she's the one that puts all of this together. She is your contact person. She does the technology to make these webinars happen. As I often say, I don't know what she does, but whatever she does it well. So without my daughter, Rachel, these webinars would not be happening. We'll provide registration opportunities for future events. Check the Berliner Special Education Facebook page, Stamford JCC, and we want to thank you for tuning in, being responsive to our webinar series, and we will see you next month. Jane and Allie, any concluding remarks?
I just want to thank Allie for coming on this evening to brainstorm with us at this roundtable. And just like the marking periods and collecting baseline data, we hope to do the roundtable at least 3 times in the year. We'll do it now. We'll do it at the beginning of the next calendar year, and then towards the end of the academic school year. So it's been a pleasure to be here again this evening, Lawrence, with you, and Allie to invite you back again this evening. If you do require any support, you can reach out to myself as an advocate, or Allie as an advocate, and Lawrence obviously as an attorney. There's also other resources out there within the community, so don't be afraid to explore things before you feel overwhelmed. And sometimes it's easier to have an advocate or someone else to talk on your behalf, because as parents, it's very difficult not to become overwhelmed emotionally when connecting and communicating your thoughts and feelings, which are extremely valid and relevant. But sometimes we do get lost in our own communication because it is emotional and it is stressful. Life can be difficult enough. So the objective of an advocate, as I see it, is to help facilitate the conversation, your confidence, and to get you to the point where you no longer need us, but you can actually do it comfortably and independently on your own. So I look forward to seeing you all again in October. And Allie, thank you for coming tonight.
Thank you. Thank you for inviting me back. It's my pleasure. And I again want to thank both you, Jane, and Attorney Berliner, and Rachel. I know you're there. We couldn't do it without you. And again, thank you for all of the audience. Your questions were great, and I hope that you found it informative. And I always learn something from these webinars too. So it really helps all of us, and looking forward to more and having a very successful school year for all of you. Thank you.
Well said. Thank you.
Bye.
Bye.